8 U.S. Code 1252C, authorizing state and local law enforcement officials to arrest and detain certain illegal aliens. In general, notwithstanding any other provisions of law to the extent permitted by relevant state and local law enforcement officials are authorized to arrest and detain an individual who is an alien illegally present in the United States, and, so we have an and here, so that means that they have to meet another requirement, has previously been convicted of a felony in the United States and deported or left the United States after such conviction. So we have two ands there. And deported and left the United States after such conviction. But only after the state or local law enforcement officials obtain appropriate confirmation from the Immigration Naturalization Service of the status of such individual, and only for such a period of time as may be required for the service to take the individual into federal custody for the purpose of deporting or removing the alien from the United States. So this one here is actually kind of a big one, dealing with your so-called sanctuary cities, where they have knowingly arrested an illegal alien, and they've had felony charges, and these illegal aliens were actually let go. They never informed ICE. They never informed the Naturalization Service. It says right here, though, they have to get confirmation from. So I guess they could put something in there, though. And I think they did. Anyway, I think they could be in trouble here on your sanctuary city status, and they've been doing that for some years now. B, cooperation. The Attorney General shall cooperate with states to assure that the information in the control of the Attorney General, including information in the National Crime Information Center, that would assist state and local law enforcement officials in carrying out the duties under subsection A, is made available to such officials. Okay, so subsection A is up here. So I'm pretty sure the Attorney General did inform these cities, and they chose to ignore it. So that's a little bit. I'm going to go ahead and go on down. Okay, so they already got stance with the city just right here, where they've been ignoring section A, part 2, especially right here. Okay, so let's go ahead now and continue. We're going to go ahead and get into penalties. So let's get into the penalties. 8 U.S. Code 1253, penalties related to removal. Okay, here we go. Penalties for failure to depart. So this is talking about the illegal aliens once they have been given a order to depart. Any alien against whom a final order of removal is outstanding by reason of being a member of any of the classes described in section 1227A of this title, who A, willfully falls or willfully fails or refuses to depart from the United States within a period of 90 days from the date of the final order of removal under administrative processes, or if judicial review is had, then from that date of the final order of the court. So 90 days from either a court order or the administrative order. B, willfully fails or refuses to make timely application in good faith for travel or other documents necessary to the alien's departure. So they are supposed to have 90 days to remove themselves from the country, or conspires or takes any other action designed to prevent or hamper, or with the purpose of preventing or hampering the alien's departure pursuant to such, or D, willfully fails or refuses to present himself or herself for removal at the time and place required by the Attorney General pursuant to such order, shall be fined under Title 18 or imprisoned not more than 4 years or 10 years if the alien is a member of any of the classes described in paragraph 1E, 2, 3, or 4 of Section 1227A of this title, or both. So we have exceptions here. Let's get into the exceptions. Exception. It is not a violation of paragraph 1 to take any proper steps for the purpose of securing cancellation of an exemption from such order of removal or from the purpose of securing the alien's release from incarceration or custody. 3. Suspension. The court may, for good cause, suspend the sentence of an alien under this subjection and order the alien's release under such conditions as the court may prescribe. In determining whether good cause has been shown to justify releasing the alien, the court shall take into account such factors as the age, health, and period of detention of the alien, the effect of the alien's release upon the national security and public peace or safety. C. The likelihood of aliens resuming or following a course of conduct which make the alien deportable. D. The character of the efforts made by such alien himself and by the representatives of the country or countries to which the alien's removal is directed to expedite the alien's departure from the United States. E. The reason for the inability of the government of the United States to secure passports, other travel documents, or removal facilities from the country or countries to which the alien has been ordered removed. And F. The eligibility of the alien for discretionary relief under the immigration laws. Subsection B. Willful failure to comply with terms of release under supervision. An alien who shall willfully fail to comply with regulations or requirements issued pursuant to Section 1231A(3) of this title, or knowingly give false information in response to an inquiry under such section shall be fined not more than $1,000 or imprisoned for not more than 1 year or both. So here they can be imprisoned or fined for giving false information. Okay. Penalties relating to vessels and aircraft. Okay, I don't think that we need to get into this. This is going to be people bringing them in. So you guys can go ahead and go on over Legal Information Institute. Pull this up. Read it all for yourself. I just went over the first part of it. We do not need to really cover the stowaways and how they're getting into the country. We're mainly covering the legality of the removal process. And there's a lot more to this. So that was penalties, and we went over state and local laws to arrest and detain an illegal alien. Then we went over the penalties. We got orders for removal. So let's look at this. Okay, I need to pause this. General orders of removal. Judicial review of a final order of removal other than an order of removal without a hearing pursuant to Section 1225B(1) of this title is governed only by Chapter 158 of Title 28, except as provided in subsection B, and except that the court may not order the taking of additional evidence under Section 2 2347C of such title. Okay, so 2. Matters not subject to judicial review. So these are the matters that are not subject to a court. A. Review relating to Section 1225B1. Notwithstanding any other provisions of law, statutory or non-statutory, including Section 2241 of Title 28, or any other habeas corpus provision, and Sections 1361 and 1651 of such title, no court shall have jurisdiction to review. All right? So they can actually do a review upon habeas corpus, which I think a few of them has done. But they also have to file or follow the Sections 1361, 1651, and 2241 of Title 28. So you can look that info up. I'm going to continue down through here. Except as provided in subsection E, any individual determined or to entertain any other cause or claim arising from or relating to the implementation or operation of an order of removal pursuant to Section 1225B1 of this title. Right there. Application of such section to individual aliens, including the determination made under Section 1225B1B of this title, or except as provided in subsection E, procedures and policies adopted by the Attorney General to implement the provisions of Section 1225B1 of this title. All right. So, Section B, denials of discretionary relief. Notwithstanding any other provisions of law, statutory or non-statutory, including Section 2241 of Title 28 or any other habeas corpus provisions, and Section 1361 and 1651 of such titles. Oh, wait, I've already read this, right? And they will not have judicial review of any judgment regarding the granting of a relief under Section 1182H, 1182I, 1229B, 1229C, 1255 of this title, or any other decision or action of the Attorney General or the Secretary of Homeland Security, the authority for which is specified under this subchapter to be in the discretion of the Attorney General or the Secretary of Homeland Security, other than the granting of relief under Section 1158A of this title. So we'd have to look up 1158A of the title to find out where the relief can be granted. Okay, orders against criminal aliens right here. Notwithstanding any other provision of law, statutory or non-statutory, including Section 2241 of Title 28, or any other habeas corpus provisions, Section 1361, 1651, as such title, and except as provided in subparagraph D, no court shall have jurisdiction to review any final order of removal against an alien who is removable by reason of having committing a criminal offense covered in Section 1182A 2 or 1227A 2A B, C, or D of this title. So you can read into that. But right there, it is telling you that unless you have a claim underneath one of these sections of the title, you don't have, a court has no jurisdiction to review any final orders, which would be given by the Attorney General or the Secretary of Homeland Security. So it's telling you right there, and what do? They keep doing it. I'm just showing you guys this. I'm not a lawyer. I'm just showing that you can look this up for yourself. A lot of it's plain English. You just have to get in. You have to dig around. You have to find the subsections and the sections of the title. So, judicial review of certain legal claims. We'll get into that one. Nothing in subparagraph B or C or in any other provisions of this chapter other than this section which limits or eliminates judicial review shall be construed as precluding review of constitutional claims or questions of law raising upon a petition for review filed with an appropriate court of appeals in accordance with this section. So basically they're saying the same thing here. You do not have judicial review unless a question of constitutional claims are brought up. Then you have to petition for the review with their appropriate court of appeals. Treatment of certain decisions. No alien shall have a right to appeal from a decision of an immigration judge which is based solely on a certification described in section 1229A, C, 1B of this title. Okay, so you already know there, unless they got a claim here or a constitutional claim here, no alien shall have a right to appeal unless you have a constitutional claim and you go through the appropriate action, or it falls within section 1229A, C, 1B, claims under the United Nations Convention. Okay, so now we're getting into so-called international law, which, remember, these are U.S. codes. And also remember, U.S. code does not trump the Constitution, and neither does international law. But the codes do adhere to the international law and try to prescribe to it. Notwithstanding any other provision of law, statutory or non-statutory, including section 2241 of Title 28. So these are Title 28. I said Title 18 earlier. Or any other habeas corpus provision, sections 1361, 1651 of such title, a petition for review filed with the appropriate court of appeals in accordance with this section shall be the sole and exclusive means for judicial review of any cause or claim under the United Nations Convention against Torture or other forms of cruel, inhumane, or degrading treatment or punishment, except as provided in subsection E. This is why a lot of people don't like to read the laws, because you always have to go from one section to another. It's like a long contract. Exclusive means of review. Notwithstanding any other provisions of the law, statutory or non-statutory, including section 2241 of Title 28, or any other habeas corpus provisions, and section 1361, 1651, blah, 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 a petition for review filed with their appropriate court of appeals in accordance with this section shall be sole and exclusive means for judicial review. An order of removal entered or issued under any provisions of this chapter except as provided by subsection E for the purpose of this chapter in every provision that limits or eliminates judicial review or jurisdiction to review, the terms of judicial review and jurisdiction to review include habeas corpus, review pursuant to Section 2241 of Title 28, or any other habeas corpus provisions. Sections 1361, 1651 of such title. The review pursuant to any other provisions of law, statutory or non-statutory. So basically, same thing that is, it's just said this 2 or 3 times in a row. You don't really have a judicial review unless you have a constitutional claim or a habeas corpus claim. Then you would have judicial review, but you actually have to call for that in order to get it. Okay, requirements for review of order of removal. With respect to review of an order of removal under subsection A1, the following requirements apply. 1. Deadline. The petition for review must be filed not later than 30 days after the date of the final order of removal. So remember, the final order of removal, you have 90 days, but you have 90 days to actually get out of the country, or they will deport you. But you will have 30 days to file a petition for review within 30 days. The petition for review shall be filed within the Court of Appeals for the judicial circuit in which the immigration judge completed the proceedings. The record and briefs do not have to be printed. The Court of Appeals shall review the proceedings on a typewritten record and on typewritten briefs. That's if they have the availability for judicial review. Remember, you only have 2 of them there that you can go through for judicial review. Well, you have the habeas corpus claim and you have the constitutional claim. Any other, the courts don't really have the right to do a judicial review of it. So 3, service. A, in general, the respondent is the Attorney General. The petition shall be served on the Attorney General and on the officer or employee of the service in charge of the service district in which the final order of removal under Section 1229A of this title was entered. All right. Stay of order. Get up here. Stay of order. Service of the petition on the officer or employee does not stay the removal of an alien pending the court's decision on the petition unless the court orders otherwise. So this is if it makes it to the court. So if you file on a constitutional or habeas corpus claim and the court grants the motion, then it does not stay the removal of the alien unless the court makes an order that otherwise that it does, or they give an extension of time. Alien's brief. The alien shall serve and file a brief in connection with the petition for judicial review not later than 40 days after the date of which the administrative record is available. It may serve and file a reply brief not later than 14 days after service of the brief of the Attorney General, and the court may not extend these deadlines except upon motion for good cause shown. If an alien fails to file a brief within the time provided in this paragraph, the court shall dismiss the appeal unless a manifest injustice would result. Like and subscribe, it helps us out. For those interested in travel, please go over to the travel channel, Ready Set Travel, over on YouTube and Daily Motion. If you are just getting tired of everything, want to take your mind off of it, you can come over to Weeby Games and enjoy watching a game, or you might even send me a message and hook up to play a game over there every now and then. I do like to get my mind off stuff every now and then, so I'll go over there and play. Oh, by the way, you can also help us out with the link down below for Buy Me a Coffee. Every now and then I do need a good coffee, keep things going. We will see you guys next time.